want me to, but you want to comment on
that's right.
At the same
that's
time.
right.
I think with oral, first and foremost, we have to be very clear that a lot of people in this country are excited about oral. And I think those political actors who've made it a habit to try and caricature it and make fun of it are not attuned to public sentiment. And I think on the MPP side in particular, there is tendency to be out of touch with public sentiment, and you have to watch it. Going into the campaign, I had occasion to listen to some of their most senior people talk about the fact that, Ghana is not Accra and all this inflation talk is nonsense. And I'm like, do you know the actual regions that were suffering most from inflation? It was Savannah was the number one. So sometimes it's not data informed, it's not data driven, and there's this out of touch attitude about some of these matters that I think doesn't serve the MPP well. But there are others as well. So my view is, first of all, oral is extremely popular. I know people who have said that they didn't buy into the entire NDC agenda, all this 24-hour economy and the rest of it. But if only the MPP will hold people accountable in Ghana and stem the flow of impunity, they'll be happy. So that's number one. Number two is we should treat oral as a matter of policy. We should think of it as a government policy. If it's a government policy, then measuring it effectively becomes critical. Because one of the big problems we have in policy making in this country is that we can't measure. So everybody throws their arms about, they do some PR, people get excited a little bit, then we forget about what exactly that they promised, and then we come back 4-year cycle, same thing all over again. Wash, rinse, repeat. If it's a policy, then the starting point is what problem are we trying to solve? And are the instruments we've designed a good match for the problem we are trying to solve? And how do we know we are solving the problem? Which is why I thought it was important to try and set some targets. So when I said that, if they can prosecute 50% of the cases, if they can secure 50% convictions, if of those 50% are willing to plea bargain and through that effort, recoveries can be made, then to my mind, they've done well. I was not saying that I'm forecasting that they will be able to retrieve 12.5%. I was setting a stretch target. I was saying that the target for me, which would be a reasonable target, is that if there's $20.8 billion or $28.9 billion, I've also seen $21.1 billion in other documents, that they've set as the damage that have been caused to the country.
Officially, what they reported to the president was 21.19.
Good. But the confusion that I think has arisen is that some people think what they are saying is that you can recover all 21.1 or 20.8. What they were saying is that it's the damage that they estimate from these cases that they've examined. So the damage to the country, the fiscal damage to the country is not necessarily the recoverable target. So I'm trying to set up a recoverable target, knowing that that is a stretch target. Why do I say it's a stretch target? Because when you look at the list of cases themselves, you will discover that in most instances, the likelihood of recoverability is very low. So take the famous $4.5 billion from the National Service
Authority.
That $4.5 billion is an estimate of harm. I don't have the methodology. What I do know, though, is that if you take all the budgets of the National Service Secretariat since it was founded to date, and you added all that up, it won't be $4.5 billion. It will be significantly less. If you take the 88,000 ghost names, it could be more. We don't know, right? Investigations have not been done. But the 88,000 that Forfeit State has identified, and I trust Forfeit State, and you multiply the income that these people, were earning, these ghosts were earning, and you come to, the region of about 1 billion cedis a year, and you say this has been going for maybe 3 years or whatever, 3 billion, you still don't come anywhere close to $4.5 billion, maybe 5% of that amount. If you take the COVID cases, or rather the COVID spending, where I think they are also estimating about $4 billion there, $1.5 billion, sorry, $1.5 billion thereabout. Most of that money, you saw it on the streets with all the free water, free electricity, food being thrown about, expenditure that was made or for Ghana Cares, which led to loans distributed randomly to all manner of people. Much of that money, we don't know if it's been covered. Ghana Enterprise Agency said they recovered some numbers. I'm trying to get the data. Nobody's giving it to me. But those monies have gone to a wide range of Ghanaians. My sense is that a lot of it was wasted. The fact that it was wasted does not otherwise mean, though, that you can use the criminal process to recover. And I think you, a lawyer, will understand this better than anybody else. To be able to recover through the criminal process, you must establish crime. Or at the very least, you must convince people that, as I gave this money as free water and electricity, I'm now so guilty. I'm going to put my hand in my own pocket and bring that money out. Think of the matter in relation to
National Cathedral.
National Cathedral is a bit more clear-cut in the sense that, the identifiable contractors, whether or not to be able to get the money out of them is another matter. But at least you could make the case that the money was ill-spent. I mean, we had the parliamentary process, which to me was inconclusive, about whether or not the contingency votes could be spent the way that they said it has been spent. Because my understanding, from a public financial management point of view, is that if you wanted to spend it in that way, the President, the Chief Justice, and the Speaker of Parliament should have agreed. We've not come to any conclusion whether or not. When you saw what happened in Parliament, it was a spectacle. Nothing much came out of that. We also know that, they've identified the Bank of Ghana quantitative easing as a problem. And they suggested that about $5 billion of the $80 billion cedis in spending was, in their minds, problematic. Yes, many of us have agreed that it's problematic. A lot of the inflationary cycle spirals that you saw came from that money printing episode. But whether or not, after that, having moved that money to banks, the banks having distributed that money through the country, people have spent it all over the place, you can actually use the criminal process to go to court and extract $5 million back. It's anybody's guess. So when I say it's a stretch target, it's because when you take these cases one after the other and you examine them, you recognize that recoverability will not be so easy. So 12.5% is not the forecast amount. 12.5% is the stretch target of how much of it they can get.
People who have, acquired lands that they say must cost between 700, as it were, $1 million instead of 500,000 Ghana cedis.
Good.
They would go to court and say, well, I acquired it through a due process.
Even if
so you're not going to get that money from them.
Even if you get it back, it's still real estate. It's not cash in the pocket of the government.
Okay.
You restore back to the government's real estate bank, properties that have been alienated from the state. But that is not cash. That's not money you can just simply spend. Okay. So when you do all the analysis and you go through each of those cases one after the other, you conclude that setting a 12.5% recoverability target is actually a stretch target.
Okay.
Then you go to the next level of the analysis and you say, okay, most of us agree that this $21 billion they've identified is money probably not well spent. That raises a concern about waste massively, because $20 billion, as you rightly pointed out, is today nearly 30% of our GDP. And it's what? 7 times or 6 times at the very least the amount of money that we are, the IMF, begging, to be disbursed to us. We've had instances where we've had to do domestic debt restructuring, etc. Because the IMF said, if you don't do that, I'm not going to give you a $3 billion loan over 3 years. $3 billion over 3 years. And then we have instances like this SML thing where they are budgeting about $3 billion. We know about $150 million have been, $140 million thereabout have been paid. Why do we have a country that goes and does an IMF deal? And there are programs that could potentially cost this country $3 billion over a 20-year time frame. So we cannot talk about oral unless we are committed as a country to fix policies that are wasteful. And fixing policies that are wasteful is not done through the criminal process. Okay. It's done through public policy where all citizens start to become vigilant about the design of these programs, and where sometimes there are inherent structures within the programs that make them very difficult to deliver value for the people. Last critical point on the oral issue. We go back to this point that it has to be a policy. So we talk about the target, the measurability, etc. Transparency is going to be very critical. I have argued that in a lot of these instances, the problems are embedded in the actual policies that are being run in this country. If they are embedded in the very policies that are being run in this country and the NDC is not willing to start reforming those programs, then we know they are not going to get money back. We've been documenting instance after instance after instance of policies that are wasting money. They've now been in office about a month. We need to see direction. SML, what exactly is the direction? Issues to do with Kelly GVG, what is the direction? Ghana card, people are not aware. Hundreds of millions of dollars is being spent on just national identity, where we have so many other priorities. All of these matters, we need clarity from the respective ministries and from the presidency, whether or not there is indeed a commitment. Then you have to think through the actual mechanics of delivering this outcome, this oral outcome. Prosecution is going to be important, investigation is going to be important. 2,417 cases. Most people don't realize the scale of that. I'll give you an example. In 2021, The total number of prosecutions by the Attorney General was 894. The total number of investigations by IOCO was 143, of which they could only prosecute 19. The target for 2022 was 50 prosecutions out of 400 investigations. NACOC, which may come in again in a future discussion, they could not prosecute anybody in this country for about 3 years. So prosecutions are not an easy thing to mount. So if you have 2417 cases, you need to really execute a number of critical strategies. One, recognize that some of the law enforcement agencies are in different ministries. IOCO reports to Attorney General. The police and the CID reports to the Minister of Interior. The NIB, formerly BNI, reports to the Minister of National Security. All of these are investigation bodies thrown about. The Attorney General Department has to have a mechanism for executing oral that gives it an interagency coordination mechanism, the ability to draw upon the investigative resource of the different agencies. Secondly, they have to tell us how they're going to do these prosecutions, because their current capacity does not allow them to do 2,517 prosecutions in 4 years. Additional. Not when you're doing criminal prosecution in total less than 900. And lastly, if oral fails, now it's very apparent to us that it will be the failure of the Attorney General's Department, because they've been saddled with the burden. So I think transparency, communication, stakeholder engagement, clarity about the strategy will be very essential, because we'll be blaming them. You know, if this target that I've set, it's not a target for them.
Yeah. So
yes, obviously everybody, you know, took serious interest in these developments. I think the right way to approach it is to look at the decisions case by case, and at the same time to consider the general principles that you've pointed out. But I was surprised when I, saw the former Attorney General elevating the bar of governance to that height, because you recall that when he was in office, we had occasion to call him the most partisan Attorney General that we've seen in our history, at least as far as my adult life. So I was very impressed that he'd elevated the bar of governance so high. I remember in the J. case, in the Saul case, the famous lack of representation case, the Ato Forson case, I had a lot of occasion to disagree with the way that he was conducting himself as Attorney General, because I felt he was being extremely partisan. But that, nonetheless, his intervention was very informational. And I think for that reason, that was very good. The only, low point was when he sought to suggest that the current Attorney General, because he has a case at the General Legal Council, is somewhat unfit for office. I think that was very unfair, because for listeners that are not aware, they would assume that this was a matter that goes to his personal integrity. It's not at all. This was a political matter. He had expressed concerns about how the Supreme Court had conducted itself in the matter of the election petition. And that was the only reason he was dragged to the General Legal Council. It had nothing to do with his personal integrity whatsoever. And I think we need to make that point very clear. But to go back carefully and look at these matters clearly, we will have to start with some of the cases. And because we don't have time, I've selected only 5 of them, so we can begin to add some flesh to the skeleton. I agree.
5 of them is almost all of them. 7 cases in all.
7 cases in all.
Yeah.
Yes. No, I thought it was 20 cases.
No.
That they were working towards. Okay, anyway.
What they have done so far.
What they have done so far, okay, fine.
7.
I heard 20 from somewhere else, but I made a mistake in that they were working on 20 cases and the 7 had been just announced. But for the 5 cases that I have, I think the decision to stop the prosecution of Democracy was just brilliant. And if they go ahead and do the same for the treason trial, that everybody in Ghana, except themselves, are aware is a complete caricature of justice, that will also be brilliant. I also agree completely with the Ato Forson case, because I investigated that matter myself as an independent analyst and looked carefully at it. I think it's one of the worst abuse of the prosecutorial discretion we've seen in this country. A use of a letter of credit is itself a risk management instrument. The reason you use a letter of credit is because there could be problems with the project or the purchase. And so if the conditions are not satisfied, money is not released. So if a finance minister signs off on a letter of credit, he's actually applying due diligence and applying prudence to then prosecute him when the subject matter experts in the ministry and the rest of who are directly responsible for making sure that those purchases were sound have been left off the hook. Makes no sense whatsoever.
Okay.
On the settlement matter,
that may not be the same as all the other cases, because that one, you can say Ato Forson and his colleagues, they won the case.
Yes, they won on appeal.
Yeah, they won.
Yes, on the submission of no
appeal.
case.
So the Attorney General is now in the Supreme Court, right?
True.
And that's where they have gone to withdraw.
They've withdrawn the case because I think it was
the appeal. The former Attorney General says he believes that case, they would have won it. They would have won the appeal.
That is, anybody has their opinion, right?
Okay.
Those of us as bystanders who had no stake in the game, I would have told you that Forson case should not have been brought at all. It was one of the worst I have seen. Anyway, on Saglemi, I have cause to agree in parts with the arguments he made. Some of the arguments that the current Attorney General presented just didn't hold water. I mean, if you said $200 million had been, part of it had been spent building houses, and so to my mind, the $200 million charge was defective. The argument that the former Attorney General makes is very solid, which is that they should have just amended it and said this is the amount of money that I felt was still in play. I was also not happy that he only addressed, and this was actually the challenge, because on the one hand, everybody's praising the former Attorney General for being transparent and seeking to justify his decision making. But on the other hand, he was not very comprehensive. So in the Saglemi matter, for instance, there are 70 charges that were preferred against the former minister. He addressed one of them, which was basically the cause financial loss to the tune of $200 million based on wrongful application. What about the 6 other accused persons, including one former minister of Works and Housing, who is also, most people don't know this, implicated in the Pualugu Dam matter, and we don't fully know the details of his involvement. So I think that in that matter, the Attorney General could have been way more comprehensive. The current Attorney General could have been way more comprehensive, because it is actually difficult to understand how everybody in that case did not do anything wrong, including the contractor and these variations that were approved and the rest of it. Then on the issue of Johnson Sema, which is why I have the greatest disagreement with the former Attorney General. No, the former Attorney General.
Rather?
Yes, because these are matters that are not only legal matters. In fact, everything here is generally public policy as well. Because even the decision to prosecute or not to prosecute is not entirely legal. There are a lot of public policy considerations that go into it. But I think this matter was extremely interesting because in the banking and finance sector, it's not only the legal issues that are important. There are other issues around macro-fiscal stability, etc., that are important. The current Bank of Governor was executing policy that his colleagues in the Bank of Ghana agreed with. He was executing policy that they agreed with, which was that we should use the emergency liquidity program, the fund that we have to support banks that are in distress, not in distress, but are having liquidity challenges. We should use it to prevent banks from failing. There are 2 types of liquidity provisions in this respect. There is the emergency type that you use, which can extend to as much as 3 months. That is, we can give you the money as a bank as much as 3 months. Then you have the intraday, which is extremely critical because the intraday means that if a bank is failing settlement, the central bank can step in to enable the overall processes in the financial system, the banking system, to continue flowing. Essentially, what happens is when you pay someone money, let's say you have a bank with you have an account with one of the banks, let's say Bank A, and you are paying somebody in Bank C. There has to be a settlement process because the bank, it's not the same, the accounts are not held in the same bank. So it's not just a matter of moving ledgers. You need to typically have a central bank situation where they debit the accounts of the different banks. If at that moment, the bank that it's being debited doesn't have money in their settlement account, it can lead to payments being failed. And this can have serious distress elements across the entire financial system. So if because of all of these factors, a decision is made that we cannot allow contagion in the banking industry, so we will give money to Unibank through UMB, because at that time Unibank, I think, did not qualify to receive it directly. And this was a matter approved as a matter of policy. How do you pick up one of them, the deputy governor, and then sue and then prosecute him? I think that was very difficult. On the UT matter, where the former Attorney General suggested that because of single obligor, 460 million should not have been paid, I could not make head or tail of it.
Explain.
Because single obligor is in respect of the bank. You are prevented from giving too much of your money out to a single person because you are concentrating risk. But the central bank is not obliged to observe single obligor if they are giving liquidity assistance. You understand what I mean? If the central bank is giving liquidity assistance to a bank, what is the single obligor issue in there? So I struggle to understand what he meant that, it was in violation of single obligor limits when the central bank was giving money to UT Bank to the tune of 460 million cedis. If UT Bank was underhand, was giving all that money out, and you suggest that they were breaching single obligor limits, I will understand, but that will have nothing to do with the central bank. The argument that we've had so far is that the previous administration was lax when the asset quality review was done in 2015 and 2016 in not pursuing it further to hold some of the banks to account. And then all of us have had policy issues today. But remember that the law that is being used, which gave the Bank of Ghana all these powers that they exercised so liberally during the resolution, that law was passed in September 2016.
Correct.
Long after these matters had occurred. So the instruments were not available to the central bank to tackle the situation in the manner in which this new administration or the one that followed them, their predecessors, were able to do. So to turn all these policy matters into a criminal indictment, I think was just bizarre, completely bizarre.
Okay.
And, you know, on the issue of the memo, now I'm pretty sure Bank of Ghana, your station is going to publish it, so I need not comment on it because now we know that that was not correct. Where I think that the previous Attorney General or ex-Attorney General was correct is in the $5 million, the claim that Honorable Atacha approved the $5 million. Because we do know on record that it was approved by the Chief Director. And we also know that at some point, there was even a consideration of charging the Chief Director for doing it without authorization of the Minister. So I'm not sure how they could make those kinds of mistakes. So that is the case by case. And what do I mean by all of this? All I'm trying to say is that we have to examine these matters on their merit, whether or not they were valid or not. And independent bystanders who are in the public policy space can make that comment. Right. On the last point, on the big issue of principle, my biggest challenge is on principle. Mm-hmm. Because on what basis have they selected 7 or 20 cases? We have hundreds of people on remand. Mm-hmm. Some of whom have been on remand for more than 5 years. I'll give you a very quick statistic. Around 2017, 2018, about 25% of all the prisoners we had in this country were remand prisoners. About 3,000. Do you know why we have only now about 995 today in remand? Justice for All program. There was a consistent policy that enabled amnesty to be applied. How do you determine upon coming to office within a week that so and so case is so urgent, is so egregious that I'm able as Attorney General to determine that as a matter of public policy we need to discontinue those cases? How did it come by the selection? And I think it would be very good if the Honorable Deputy Minister Designate walk us through how did they what was the filtering mechanism? Mm-hmm. Is it all defense attorney petitions? If so, was that an open call so that other defense attorneys in this country can approach them? Because I think that baffled me. Secondly, even if there was a mechanism to enable fairness to be applied in this respect, on what basis then do we have a situation where for the same particular situation, an individual gets off, and others who similar facts have been applied to their conduct don't get off? It gets very, very confusing. Right. So those are my concerns.
Thank you very much. And so you should be answering questions. And Dami had very, very critical questions for you